Welcome. This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Thank you. I am pleased to introduce Judge Kevin Murphy today. Judge Murphy brings to his ADR practice 28 years of experience as a judge in the California Superior Court of Santa Clara County, during which time he supervised both criminal and civil divisions. And before his ascension, Judge Murphy spent 9 years as a Deputy District Attorney, Santa Clara County. Along with being an adjunct professor at the Santa Clara University Law School for 9 years, Judge Murphy served as supervising civil 11. Judge Murphy has been one of ADR Services, Inc.'s most sought-after neutrals, performing multiple services, including mediator, arbitrator, discovery referee, special references, and mock arbitration and trials throughout California. His practice area ranges across the breadth of legal dispute types with a particular focus on employment, business, and real estate matters. Without any further ado, I turn it over to you, Judge Murphy.
All right, thank you, Katie, and good afternoon, everyone. I appreciate you taking the time to spend roughly the next hour with me. I recognize that most of you are here to get your continuing legal education credits out of the way, something I certainly have to do every so many years. But I'm going to do my best to make my presentation as meaningful as possible for all of you. I'm going to be discussing something that I really feel strongly about and have for a number of years, and that is alternatives to the norm in terms of the court process. It is obvious that the courts are backed up because of COVID. We're into 2 years now of the COVID epidemic. And just when you think the situation is improving, then another variant comes along and we hear about other courts closing down, trials being continued, only criminal trials proceeding, shortages in the clerk's office. This backs up, as you know, not just the trials, but motions and everything associated with litigation. This is not a new problem, in my opinion. Even prior to COVID, the courts were backed up. I almost always, when I conduct a mediation, ask the attorneys about the trial date and when the case will actually go to trial, as opposed to the set trial date, the real trial date or the date certain. And as time progresses, those dates go out further and further. I think there are real alternatives out there, and those alternatives I will be discussing primarily will be the subject of references and arbitrations, although I'm also going to comment briefly on the subject of temporary judges. I think there's been a resistance to these alternatives, the product of, I think, a misunderstanding of these alternatives and what I sometimes describe as myths about these alternatives. Myth number one is that if you proceed with these alternatives, especially arbitration, there is very little appellate relief. And if you take an initial look at arbitration, that's the case, but there's something that can be done about it. And I will be discussing that alternative when I talk about and refer you to the cable case. That's myth number one. Number two is that it's cost prohibitive. I don't think that's the case. I intend to make the case to the contrary, and in the process of doing so, to suggest some alternatives to you to keep costs down. The final myth is that it's an unfair process. And that is the result, I think, of two things. The arbitrators, the special reference referees, the temporary judges primarily older people, generally retired judges. And let's face it, some of you out there think that we are out to pasture, and maybe some of us are losing our marbles. Not only that, there's a feeling that we're interested in repeat business. Therefore, we're going to make decisions that will favor economically what we do in the future, whether it's with mediations or arbitrations or references. I really don't think that's the case, and I'm going to address that subject as well. Now, in terms of the handout, a couple of comments I'd like to make about that. Number one, I tried to put as much significant law in there as possible. So if you are taking notes, and there may be 5% of you that are actually doing that out there, you don't have to write. I've listed the key statutes, the key cases. I have a section entitled 5-star cases, which lists 4 very important cases together with the case citation. Number 2, you will notice if you're looking at the handout from time to time, the letter W circled. That W stands for win. And the reason I put it there is when I participated in the creation of the subject for this presentation, I wanted something that would pique your interest. So in addition to discussing cost savings, I took on the challenge of trying to explain in the next 60 minutes how you can win at such a process. Quite an endeavor. I hope to give you at least some tips in that area, but the W is meant to signify something that I think will be especially helpful to you, although there is a section of my handout, and I'll be commenting on the subject of things you can do to prevail. Finally, the handout includes my photo. That is, in fact, my photo. It is somewhat dated, but the crack marketing team at ADR Services touched it up a little bit. That's not a double, that is me. And it's part of our attempt here at ADR Services to reach out to you younger lawyers, as well as some of you senior attorneys. So with those comments in mind, the first thing that I'd like to make brief reference to is temporary judges. And you will notice in your handout, and I will point out to you now, that the the Supreme Court of the state of California has recognized, and the state constitution specifically provides in Article 6, Section 21, that temporary judges can be appointed by the courts. Those judges, if appointed, have the power of trial court judges, all of the powers, and hence the appropriate substantive and procedural law would apply to any decisions that they make in the process that they conduct. Also, in some of the California statutes, I made reference to the probate code. There are several sections which allow for the appointment of temporary judges. And in the case of the probate code references I made, you will note that the trial process is a summary trial process without the necessity of discovery. So it really provides for, in an appropriate situation, a streamlined process. Now, with reference to temporary judges, it's important to understand that they cannot be forced upon you. They require your consent, the consent of both parties. Also, the court still retains the ability, even if you request the appointment of temporary judges, they have the discretion to say no. So I wanted to make reference to that. And much of what I say in terms of information about references, and to a certain extent about arbitrations, holds true regarding temporary judges. But let me move on to the subject of references. References refers specifically source-wise to California Code of Civil Procedure, Section 638 and 639. And those statutes provide for certain situations where the court can appoint what the statute refers to as a referee. There's several important things to understand about references. Number one, the distinction between general references and special references, and it is a distinction that has significance. A general reference is defined by Code of Civil Procedure, section 638A. And as part of the language in that section, and I've included it in the handout, the statute provides that a referee appointed under 638A has the ability to consider any and all issues. Thus, the court has the power to appoint a referee under 638A of the Code of Civil Procedure who can hear the entire case. Now, that same judge could be appointed for a limited purpose to hear motions or what is frequently done to resolve discovery matters. But this is a full-blown or almost full-blown alternative trial option. I say almost because a referee appointed under 638A, although that person would have most of the powers of a superior court, not all of them, and the powers are not as extensive as one who is appointed to be a temporary judge. In terms of special references are defined by Code of Civil Procedure section 638B and 639. And basically, if you examine those sections, you will find that a referee can be appointed for almost any purpose whatsoever. The most common example of a special reference appointment is a discovery referee. We're all familiar with that. In fact, I think some attorneys believe that the only type of referee, or one of the few types of referees available to the courts, is a discovery referee, when in fact, a referee can be appointed to address a wide range of subjects. Those subjects, besides discovery, includes motions. An anti-SLAPP motion that could be assigned via a special reference. A dispositive motion that could be assigned via a special reference. One thing that I think can be very helpful is there are certain cases where there are key dispositive issues, and I'm not talking about dispositive issues within the context of a summary judgment motion or a summary adjudication motion. I'm talking about key issues that, if resolved, will lead to a resolution of the case. The issue might be one of contract interpretation. Hence, via a special reference, a party could be appointed to decide an issue of contract interpretation. The issue might be, and you see a lot of this, valuation of property. I encounter a lot of cases where there's a dispute over the value of the real property, whether it's a residence or a commercial property. Or I have encountered cases where it's the value of a company or the value of the shares of a company. Those are special issues that, if resolved, may lead to the resolution of a case. And therefore, those are subjects that can be addressed through a special reference. Probably in a more unique area, and just focusing upon my personal experience, I have had occasion in a number of situations to be appointed by the court to conduct elections in conjunction with nonprofit organizations. Somewhat rather unusual, but within the context of certain nonprofit organizations, and oftentimes within the confines of a religious organization, disputes arise concerning the election of the controlling body of that organization. Hence, I've had, and these have been really interesting experiences. I've had the opportunity to preside over an election at a Sikh Gurdwara, which is the term for their church. And I spent approximately 8 months supervising the election from the very beginning, where the rules had to be agreed to the actual election process, which involved locating an organization to actually set up the polls, count the ballots and things of that nature. I had a similar experience at a Muslim mosque and other nonprofit or religious organizations as well. These experiences were probably some of the most interesting I've ever had in my professional life. But the point I'm making is that in terms of looking at alternatives, it's important to understand that these referees, as we use that term, can be used for more than conducting discovery. So I would urge you to consider that, especially if it's going to save time and money for your client. But continuing with the subject of references, let me make a couple other key points. The next key point has to do with consent. Under 638 of the Code of Civil Procedure, the parties have to consent to the process. There has to be consent on both sides. 639 is different, however. It doesn't require mutual consent. Hence, one party to a lawsuit can petition the court and ask for the appointment of a special reference. And the court, for that matter, can initiate the process and appoint a special reference. Parties can object, obviously, and the issue can be debated from the standpoint of legalities and practicalities. But it is something that is available that should be considered. Now, I mentioned a few moments ago that the distinction between a general reference and a special reference has significance, and it does for a number of reasons, but perhaps the most important significant difference between the two is this. A decision made via a general reference is a decision of the court, just as other decisions made by the Superior Court. Hence, when they're entered, they operate as the decision of the court. Now, you have full appellate rights as it relates to that decision, but it is a decision of the court. On the other hand, if the reference is a special reference, the opinion of the referee is advisory only. So the Superior Court does not have to accept the advisory opinion of the referee. There is case law out there indicating, and this is not surprising, that the Superior Court will give deference or significant deference to the decision of the referees. And if you encounter a situation where a referee is making a factual finding concerning credibility, it's like any other situation where you're trying to appeal a credibility decision, that's going to be difficult to disturb. Nevertheless, if you're dealing with a special reference, the decision can be challenged and objections can be made to the advisory opinion. Where this may come into play as a practical matter in decisions you make concerning references is in the area of discovery. Once again, that's the most common type of reference that we encounter. If you want to maximize your ability to challenge decisions, then the way to go with a discovery referee is not via general reference, but a special reference, because if you don't like the decision of the referee, you can then challenge it with the Superior Court. And then, of course, you have full appellate rights to challenge it thereafter. So those are the basic distinctions between the two. And not wanting to be overly repetitive, I really urge you, as I have urged parties that I encounter in my practice, to consider some of these alternatives if it's going to lead to a quicker resolution of the case. It may not be dispositive of all issues, but it may lead to something that is dispositive of something significant, whether it's a damage issue, a contract interpretation issue, which can then lead to a settlement of the case. I would like to move forward from the subject of references and do some comparing and contrasting between the subject of references and arbitrations. Sometimes there's some confusion there, both with reference to the vehicles in general and then the law that applies. So I would like to address that. And in the process, focus on the myths, or at least one of them at the outset, that I made reference to at the beginning of my remarks. In terms of comparing arbitrations to references, let's take the arbitration process. If you look at the Federal Arbitration Act and you begin there, you will find that there are limited appellate rights. If you look at the California Arbitration Act and California law, you will notice there are limited arbitration appellate rights. To give you a flavor of how difficult it is to appeal an arbitration decision, I included some language in the handout which references Code of Civil Procedure section 1286.2, which defines when you can appeal a California arbitration decision. If you take a close look at it, basically you have to establish some form of wrongdoing on the part of the arbitrator, and references made to corruption and misconduct and failing to disclose. Or alternatively, you have to establish that the arbitrator exceeded his or her powers. Now, that doesn't mean they made a bad decision under the facts of the law, because under general principles relating to arbitration law, whether it be under California law or federal law, and here's the big criticism of arbitrations as it relates to appeals, you cannot successfully appeal a decision by the arbitrator on the grounds that he or she made the wrong decision factually or as a matter of law, even though it may result in an injustice. Now that sounds unfair, but those who write about this, the appellate courts, feel that that's the trade-off for an efficient arbitration process, namely that you run the risk of the arbitrator making an incorrect decision. So how then do you deal with that problem? Returning to my comments earlier that it's a myth that there are no or limited appellate rights. The answer is found in one of the cases that I made reference to in the handout, and that's the cable connection case. In that case, the California Supreme Court decided that you could include in an arbitration agreement expansive appellate rights. And I included some of the language from the arbitration agreement that the court was taking a look at. And the arbitration agreement in question read that the arbitrator shall not commit errors of law or legal reasoning. And if they do, they could be reversed on appeal. Now, that's not the case under the law, as I mentioned to you. Therefore, if you are concerned about maximizing your appellate rights, and if that is your primary complaint about arbitration, the way to deal with it is in drafting an arbitration agreement where you clearly explain that any decision of the arbitrator can be appealed for not just the statutory reasons, but if there is an error of fact or law. Now, if you do this, there's several things that you need to bear in mind. Number one, with any agreement, you need to clearly spell that out. So it's very important you make that clear in an agreement. Number two, you need to recognize that under federal law and the Federal Arbitration Act, you do not have that option. That is to say, there is case law that does not allow under federal law for a party to expand appellate rights. So you are in a position of facing an obstacle federally that you cannot overcome. But under California law, you can do that. Now, one problem you encounter and perhaps this is occurring to you at this time, is this. We've all looked at some of the basic arbitration agreements signed by individuals pre-litigation. You see a lot of these in employment law. And what I've noticed is, number one, they're very difficult to read. I mean, it's hard even to get a copy that you can read because it's so poorly done or it's so old. Some of the language is rather archaic, is difficult to follow, is contradictory and ambiguous. And it certainly doesn't spell out the types of additions you might want to make to an arbitration agreement. But you're not lost. The reason I say that is if you're dealing with that, you can enter into a stipulation with the other party and expand the scope of the law that applies to an arbitration. I would think that most adversaries would have no problem in agreeing to enter into a stipulation that appellate rights could be expanded in arbitrations. I mean, in theory, nobody wants the wrong decision to be made, I guess, unless it favors you. But you're not going to know that in advance unless you've selected an arbitrator, hoping that that will actually be the case. So don't lose sight of the fact that these arbitrations, and for that matter, reference agreements that are read pre-litigation, can be crafted in such a way that you can provide for things that will favor your position. So again, regarding the myth about lack of appellate rights, you have full appellate rights with references. You have full appellate rights in connection with temporary judges. Under the general principles of arbitration law, you do not, but in California, you can deal with the problem under the cable case. And I have made that recommendation over the years, and I don't think I've come across a single case where the parties have drafted an arbitration agreement and included expansive appellate rights. And I think it's something that's have been overlooked, and it's something that should be considered. And if you're able to deal with that objection to the arbitration, then maybe everybody will be more agreeable to the arbitration process. Now, continuing with the distinction or the comparison between arbitrations and references, the law is different. And let me give you several examples. Probably the primary example is in the area of discovery. Under the Federal Arbitration Act, there are limited discovery rights. Under the California Arbitration Act, there are limited discovery rights. Now, you may be thinking of the following, perhaps not mindful of the specific statute, but here's a mistake that I've encountered made by some lawyers. They look at Code of Civil Procedure Section 1283.05, which is part of the California Arbitration Act, and talks about discovery. They look at it, and if you just read it, it appears that in an arbitration in California, you have almost full discovery rights. However, you need to read that section, 1283.05, together with 1283.1, because when you read 1283.1, you find that what appears to be discovery rights similar to what exists in a normal case in a court of law only applies to litigation where the plaintiff is alleging wrongful death for personal injury. And 1283.1 specifically provides that you have to include that other statute in order to have full discovery rights. The language of 1283.1 reads, by their agreement so provided. So if you want full discovery rights in an arbitration in California, include 1283.05 in the language of the agreement. If it's not there in the original agreement, signed pre-litigation, enter into a stipulation if that's at all possible. Now, of course, one of the advantages of arbitration viewed by some is that there are no full and complete discovery rights. That's part of the efficiency of the process. And if you look at the discovery rules that are applied by any organization, such as ADR services, you will find they're limited and pretty much controlled by the arbitrator. And a lot can be said for limiting the amount of discovery. Oftentimes it's not necessary, and it can save a lot of money. But in terms of if your concern is having full discovery rights, then you need to read those two statutes together. Continuing with the point that there's a difference in law between arbitrations and references, that's true in dispositive motions. Not every private organization that administers arbitrations allows for summary judgment, summary adjudication motions. I gave you one example from the AAA, the American Arbitration Association's commercial rules, Rule 33, and part of that rule reads that a dispositive motion may be allowed, not must be allowed, and part of the language in order to allow it to be allowed requires that if the arbitrator is determining whether it's appropriate to do so, it must be one that is likely to succeed. That's a pretty significant burden. It reminds me to the type of the type of burden necessary to get injunctive relief. So when we look at the differences between references and arbitrations, and we compare the law, that is another difference. And of course, an obvious difference relates to the rules of evidence. If you look at the rules that apply in private organizations that conduct arbitration, you will notice that they are what I describe as relaxed evidence admissibility rules. Fundamentally, the arbitrator is governed by the relevance rule. And relevancy, no matter how it's defined, whether it's by Evidence Code Section 210 in California, it's extremely broad. So in terms of evidence admissibility, a lot of evidence is coming in. I encounter attorneys that frequently raise hearsay objections during arbitrations, not recognizing that, or being used to conduct themselves in courts of law. It slips their mind, but the rules are very different. And even under California statutory law, and I made reference to another provision of the Code of Civil Procedure, Section 1282.2. If you take a look at that, it reads that the rules of evidence and judicial procedure need not apply in an arbitration. Not only that, a fact not noticed is that oaths are not even required under that particular statute. It reads an oath upon request. So these rules are very different. Now, if you have a problem with that, again, the solution is simple. You can enter into an agreement with the other party, and you can create a situation where you'll have the type of evidence admissibility rules that you would like. So there are some significant differences between the two. But again, I think the most significant difference of all relates to appellate rights, and that is a problem that can be resolved. I'd like to move on now to myth number 2, namely the cost of these alternatives. And I want to begin with a fact that you may find interesting. I probably, in the 11 years I've been with ADR services, have been assigned maybe 200 arbitration cases. Obviously, most of them never go to trial. My typical billing in an arbitration case is 3 hours. That is to say, someone who files an arbitration case with ADR services, they pay the administrative fee, and that's common in any private organization. And then I charge an hourly rate. Since most cases settle in arbitrations, And because in most arbitrations, at least I've experienced, there are no dispositive motions, by the time the case is completed, usually with a settlement, maybe a year and a half down the road, a year down the road, I billed out a total of 3 hours. So it doesn't necessarily have to be expensive. In a typical situation, those 3 hours consist of a billing for reviewing all the papers that have been filed to initiate the arbitration. That would include pleadings, agreements to arbitration, court orders, if there are any. An initial arbitration management conference, where I set up a structure to manage the case, a review, a status review prior to the arbitration hearing date, and maybe a few other minor things. So it doesn't necessarily have to be expensive. I would also say, if the attorneys representing all the parties work well together, and as many of you know, you can be fierce adversaries once you get into a courtroom or into a forum involving litigation like an arbitration, but you can still get along outside of those locales. If you work together, you can keep costs down. And it's meeting and conferring, it's focusing on issues, it's minimizing discovery. Speaking of discovery, in my opinion, the biggest waste of money that I have seen in litigation, and this includes when I was a judge for 28 years, what I see now when I am a reference referee or a temporary judge or an arbitrator, is formal discovery motions. Frequently, they are the product of somebody not understanding discovery law. Rarely, and unfortunately, they may simply be attorneys that don't like each other. And that can lead to formal discovery motions that are very expensive and involve clients having to pay money that they shouldn't have to pay at all. Let me give you a couple of examples. I handled one case involving discovery dispute. It was a lawsuit involving a law firm, several law firms from Illinois, from Chicago, several from California. There were a number of lawyers, everything from first position lawyers, second seat lawyers, lawyers that carried briefcases, the ones that come into court and take notes. I've often wondered what they're noting, but in any event, that's a situation. Those lawyers got along, and they narrowed the issues down to the point where I believe we had only 2 formal discovery hearings the entire time. I also handled another case where the lawyers did not get along from day one. They fought over literally everything. The costs of discovery were tremendously significant. I said several times to them that I felt guilty charging them. That did not slow them down. It's a waste of time in most situations to engage in formal discovery litigation. Now, there are things to litigate in discovery, namely in the area of privacy, and I use that in a very broad sense to include everything from attorney-client to trade secret. But if you can avoid formal discovery disputes, that can really save a lot of money. How do you do it in a reference setting or an arbitration setting? You meet with the arbitrator or referee and you discuss ways to keep costs down. What I do now, after observing the disaster I made reference to, is I let the lawyers know, first of all, it makes no sense to engage in a lot of formal discovery litigation. Number 2, why don't you consider letter briefs? Why don't you consider page limits? And after meeting and conferring, if you have a problem, come to me first. I will try to indicate a tentative decision. If that doesn't resolve the matter, then you can litigate in a more formal and costly way. And that seems to save a lot of time and is usually an accepted alternative. In terms of other ways to save costs, try to identify dispositive issues. Again, I returned to several examples. If the outcome of the case is going to be determined by an interpretation of a contract, consider addressing that issue, whether via special reference or before the arbitrator. Mediate sooner rather than later. I know there are arguments both ways. If you mediate too soon, you don't have all the information you need. If you mediate too late, you've spent all sorts of money on a case preparation, so that affects the amount of money for settlement. I think it's better, as a general rule, to mediate sooner rather than later. In certain situations, and it involves a potential conflict of interest, you can agree to mediate before the arbitrator. That can lead to a savings of money and a resolution of the case. And then if the matter is not resolved at that point, and there's no desire to waive the conflict, then you move on to another arbitrator. Now that sounds like it would lead to excess time, and it could in certain situations, but most cases never go to trial. So that's an alternative to consider. And then, of course, using remote processes like Zoom. By the way, I've presided over roughly 5 or 6 Zoom arbitration hearings or trials. In every situation, they went well. Everybody could hear. I could see witnesses better through the Zoom process. We used interpreters, and they worked very, very well. With ADR, we have an entire Zoom team that can even give you a class on how to effectively participate in the Zoom process. I saved towards the end the challenge of explaining to you how to win, okay? And obviously I can't tell you for sure how you're going to win. I can give you pointers, and I've made reference to several things that I think are really important to know. The most important thing, and this is going to sound so fundamental to you, is to understand what law applies to the process. If it's a reference, you know it's the law that applies in courts of law. If it's an arbitration, it's going to be something different. You need to find out and read what applies. Let me digress here with a quick war story. We've all had eccentric professors, whether in college or law school. I had one who only lasted a semester of teaching, and he would show up in class. He was Scottish, and he would carry the case book, and he also had a flask. And when I say flask, yes, I'm talking about a container, and we all believed it contained alcohol. And during the course of the class, if there was a tough question, we noticed he would go to the flask and take what we used to refer to as a pull on the flask. Once we noticed that, we used to pepper him with questions about the rule against perpetuities. And we noticed that he went to the flask on many occasions. Now, let me get to the point. There was one thing I learned from this particular professor. Whenever you asked him a question about a statute, he responded with his accent, just read the Fulton statute. If you said you read this statute, he would repeat it, just read the Fulton statute. If it was a case involving a statute, the same comment, read the Fulton statute. Well, he had a point there. He didn't exactly express it in a professional way. You would not believe on how many occasions I presided over arbitrations where the attorneys did not read the Fulton rules. So my advice to you is read the Fulton rules, whether it's the rules that apply by an organization like the American Arbitration Association or ADR services, or how about your own arbitration agreement? I had a case not too long ago where they didn't apply the correct law, and it was in the agreement that they drafted. So that is one piece of advice that I think will be productive. Number two, in terms of winning. Big criticism, especially of arbitrators, as I mentioned to you, is basically we're a bunch of old guys. And some of us are losing our marbles, and some of us want repeat business. Well, who chooses the arbitrators? In most situations, the attorneys do. So if you choose somebody, you have the opportunity to put in a little effort and do a little bit of investigation so that you come up with somebody that isn't going to be difficult or someone that knows what they're doing. And in situations where you cannot personally select someone by agreement, there's a process where at least you could submit names, or with some organizations, there's a system where there's 10 names and you strike certain names. The point is, you have input in the selection. Now, let me digress again for the second time in the last few minutes. And I have to be as vague as possible when I tell you this. I was presiding over a motion, let's say within the last couple of years. And it in fact, it involved a reference situation. The attorneys were arguing the issues. And then one of the lawyers suddenly, as part of his argument, points out that the other side hired a private investigator to investigate me, the referee. And of course, everybody wondered about the relevance of that. The attorney that brought it up said it was very relevant. Of course, it was not relevant at all. Those of us who litigate, we know why the attorney brought that up. It was designed to somehow impact me as if I would color my decision because the other side allegedly had a private investigator apparently following me around. Well, 2 points. Number one, from that situation and the arguments I heard that day, I was able to go home that evening and explain to my wife why a Roto-Rooter truck had been parked in front of our house for 2 weeks and there was a guy in the front seat with binoculars. So that answered that question. And I called off security because I live in a gated community. But here's the real point. If you're going to invest that sort of money in investigating the arbitrator or the referee, why don't you spend the money before you select them to make sure that you end up with somebody that you're going to be satisfied with? But let me continue with some other tips to assist you in prevailing, whether it be a reference or in front of an arbitrator. I sometimes think that oral advocacy at court trials or arbitration procedures or references is kind of a lost art. Almost in every situation where I'm presiding over some type of trial, whether it's an arbitration or a special reference trial, I always give the attorneys the opportunity to argue orally. On the other hand, I know that all attorneys like to submit written arguments. I have not had a single case, or there's not a single case I can recall, maybe one, now that I think about it, in 11 years, where someone took the opportunity to present an oral argument. It was all written. There was no suggestion of, well, can we argue part of it and then submit a brief? I think oral advocacy can be powerful if you're good at it. And I think it's a mistake to lose sight of that. And as a general rule, if it is your general rule, not to argue orally. Other things that can lead to some success as it relates to litigating these alternatives. When it comes to arbitration, you have to understand fundamental law as it relates to federal preemption. The federal law provides, and this is going to be very sketchy because there isn't time really to go into this particular topic, but if it has anything to do with commerce, and anything to do isn't the precise language, then federal jurisdiction will be found. And the Supreme Court has made it absolutely clear that federal law will predominate. And as we all know, there is a preference in our law, whether you like it or not, for arbitrations. However, there's also a preference in the law by the United States Supreme Court for the written agreement. And the Supreme Court will not stand in the way, with one exception that I can think of that I've made reference to this afternoon, that is expanded appellate rights in federal cases. If you want to craft an agreement that creates broader discovery rights, a broader scope, provides for following local law, that sort of thing. If it's ambiguous, the interpretation will be in favor of federal preemption. So that's something to keep in mind. I have included in the handout reference to several cases which I have labeled 5-star cases. I've referenced several of them already. Actually, I've only referenced one, the cable connection case. That's the first case listed there. Tarrant Bell is a very good case. It was written by Justice Chin, who's with ADR Services now, and it dealt with the subject of a reference and when the court has the discretion to deny a reference, when there's a reference agreement, if the result could lead to an inconsistent decision by the arbitrator, inconsistent with what might be decided in a court of law. And if you look at Tarrant, you'll see there were a number of individuals involved. Some were subject to a reference agreement, some were not. And that decision allowed a party to argue there shouldn't be references, period, because there could be inconsistent results. The Axtron case mentioned is an excellent case dealing with the subject of discovery in California, particularly as it relates to third party, or probably better termed non-party discovery. One of the problems with general discovery law in California, that is, if you don't provide specifically that 1283.05 is part of the arbitration agreement, is that there are no non-party discovery rights. I see this situation arise all the time in some arbitrations. They will subpoena a non-party for a deposition and want records. And the other party objects. Well, there's no right to those records from the non-party, absent 1283.05 in the agreement. And therefore, there's no right to a deposition. Well, that can create quite a problem if you need that information for your case. Now, there is sort of a way around it. It's not a discovery way. You can subpoena the non-party to the arbitration hearing with the records, but that defeats the purpose of discovery. The Volt case mentioned deals with the subject of the fact that if you clearly spell out a preference for local law, California law, as opposed to federal law, then the United States Supreme Court will uphold it. I think perhaps one of the most important things to bear in mind as you reflect upon the comments that I've made so far is so many of these potential problems, whether it's lack of appellate rights, concern about costs, fairness, so many of them can be addressed by drafting through the wordsmith process, if you will. So make every effort, if you're drafting an agreement to arbitrate, pre-litigation, or a stipulation, to bear all of these things in mind and to be comprehensive when you do so. And also to keep costs down. think about ways to keep costs down. And one way I haven't even referenced is if you're considering, say, an arbitration or a reference and you're worried about costs, set up a pre-selection or pre-retention agreement with the candidate who's going to be your referee or your arbitrator. Talk with him or her, ask them how they manage a case and how costs can be kept down. I've had several of those conferences, and I tell them things they can do to keep costs down, and it's not just avoid formal discovery. I make suggestions in terms of keeping the paperwork down. If you send bankers boxes filled with material to somebody, that person, if it's me, I'm going to read it because that's part of being conscientious. Oftentimes, all that information is not needed, and there are many ways of keeping costs down. As I wind down, let me just make the following comments. I'm the type of person that loves talking about the law, even at this late stage of my life and what I do professionally. I love what I do. I'm not one that does things because I'm bored in life and what else can I do? I actually love doing mediations and arbitrations. If any of you have any questions about any of these subjects, I'm happy to talk with you about them. I love talking about the law. And the way to set up a discussion is very simple. Send me an email. Tell me you attended this conference, and it's not even necessary whether you attended or might have slept through most of it for all I care. Contact me. Tell me that you're interested in discussing some subject. I'll either respond to you by email. I'll set up a phone conference. I'm happy to do it. I really am. So I see we are winding down in time. So Katie, I'm going to, before you jump in and give me the hook, I'm going to turn things back over to you.
Well, that's very insightful of you, Judge Murphy. I'll put my hook and crook away then. Thank you so very much for all of this information. And let me drop the handout materials into the chat once more. Everybody, if you haven't downloaded those, I recommend that you do so. You can also find them on our website, adrservices.com. I see that my colleague Kathleen did post Judge Murphy's email address in the chat as well. It's also at the end of the handout materials. If you do want to take him up on that opportunity to get in touch and discuss any of these points that he has mentioned during this presentation. Thank you so very much, Judge Murphy. That was very insightful, and I would like to echo some of the comments that we received to thank you for putting together such a comprehensive explanation of something that's pretty confusing sometimes.
Well, thank you, and thank you everyone for putting up with me, and be sure to read the Fulton rules and feel free to contact me anytime. So have a good afternoon and enjoy the remainder of the presentations.